सब्सक्राइब कीजिए चैनल लर्निंग सेशंस को एंड बेल आइकन को दबाइए लेटेस्ट JAIIB CAIIB वीडियोस को सबसे पहले देखने के लिए।
Hello friends, welcome to learning sessions and today in this video tutorial we will cover Lok Adalat, which is an important topic of legal and regulatory aspects of banking. Before starting this video, let me tell you, you can download our JAIIB app for previous year questions. The link is in the description. So let us start the video now. Lok Adalat is similar to civil court and this is organized by state authority, district authority, the Supreme Court, Legal Services Committee or High Court Legal Services Committee, and Lok Adalts are created under Legal Services Authority Act 1987. I repeat, this is important that the Lok Adalats are created under Legal Services Authority Act 1987. And Lok Adalat has jurisdiction to determine and to arrive at a compromise or at a settlement between the parties to the dispute. Means the parties who have the dispute, the Lok Adalat has jurisdiction to determine and arrive at a compromise, at a common settlement between the parties. And the Lok Adalat deals the cases where both the disputed parties agree to refer to the issue to Lok Adalat. And the case where one party approaches the Lok Malt and Lok Adalat is satisfied that there are chances of settlement. In this case, where one party approaches the Lok Adalat, the Adalat issues notice to the other party. In case of Lok Adalat, only the opinion of the cases can be taken. Only those disputes can be taken which are in the scope of the Lok Adalat. And the cases which includes the offences which are compoundable under any law cannot be brought up in the purview of the Lok Adalat. It means that Lok Adalats do not possess any authority of its own to pass the judgment. They don't have any rights to pass the judgments, and their awards, the decisions taken by the Lok Adalats, are in the form of consent decrees, and no appeal can be taken up against such any award, and it possesses no binding on all the parties, procedures or powers. Civil Procedure Code is applicable on the award taken by the Lok Adalat, which means Lok Adalats can send summons, take evidence on oath, initiate ex parte proceedings and determine court procedures. And where the compromise is not reached, the case when there is no compromise between the two disputed parties, the case will return back to the court from which the reference was received for continuing the case here. Now what the RBI guidelines are on Lok Adalat? To settle banking disputes involving smaller amounts, so as to increase the usage of forum of Lok Adalats, RBI issued some guidelines during April 2001, and these guidelines were for banks and financial institutions to follow. The first guideline is regarding the amount. The cases which involve an amount of rupees up to 20 lakh can be brought up in the purview of the Lok Adalats and can be referred to Lok Adalat. Now what type of borrowers or accounts can be taken up there? All the NPA accounts, both suit filed or non-suit filed, which are among the categories of doubtful or loss category, can be taken up, can be referred to the Lok Adalat. No cutoff date is suggested because Lok Adalat is an ongoing process. Then third is settlement formula. A decree. Decree means an official order which has lawful power behind it, is sought to be from Lok Adalat for principal amount and interest claimed in the suit. And once the full payment of the decree amount is made, a discharge certificate must be issued by the bank or financial institution, and the repayment period is to be within 1 to 3 years. And the negotiated agreement between the disputed parties must contain a default clause. Means if the borrower does not pay the due amount regularly within the repayment period, entire debt will fall due for the payment and bank may initiate legal proceedings. That is a clause in case of default. And fourth and the most important point that is a necessity in case of settlement is that the representing officers from both the sides must have sufficient powers to accept the compromises worked out within the bank policy framework. Means if the court, the Lok Adalat, makes a compromise on some particular amount, then the officer must process some powers to work out it, and he must respond proactively to the suggestion of the presiding officer of the Lok Adalat. So these were some of the guidelines that are issued by the RBI, so that most of the cases that are amounting up to rupees 20 lakh could be make up to the forum of Lok Adalats so as to settle down the cases, because there are numerous cases that are pending in the regular court. And as I told you before, it is very important point that it is not necessary that the loan default account cannot be on-go in regular court. It can be suit filed or non-suit filed. And in case where the bank matters that exceeds the ceiling amount of rupees 20 lakh, the Lok Adalats organized by debt recovery tribunals or debt recovery appellate tribunals, bank can take up the matters there. And this is an order, this is in suggestion by the worthy Supreme Court that the personal loan cases up to rupees 10 lakhs preferably settled through Lok Adalat. And individual banks and financial institutions must be more proactive and should take the responsibility for organizing the Lok Adalats. The institutions should be get in touch with the state, district or Tehsil level legal services authority for organizing the Lok Adalats. Banks should report the progress to the RBI at quarterly interval within 1 month from the quarters ending March, June, September and December. And RBI monitors the progress made by the institutions in effecting recovery under the scheme. So this was the end of the session. I hope you would have liked the video. If you really like this video, please share this video and like this video, and also do not forget to subscribe to our channel so that you get updated whenever we upload a new video. Thank you so much and stay tuned.